Your Honor, may it please the court, the respondent Cassie Hall appears in person. She's just off to my right here, just off camera. I apologize. We're working off a laptop today, and she appears with counsel Jessica Levitt.
Very well. This matter comes before the court at this time for review. Docket notes from the last hearing held on April 28th indicate that there was a PFA case to be heard in Sedgwick County on May the 7th. Court found that the mother's denial of weekend visitation was not justified. The father gets a makeup weekend visit. The father's denial of the child's location during the visit, where, in other words, where he was staying, was also wrongful in the view of the court, and he must disclose to the mother where the child will be staying. Ms. Smith was to complete journal entries, and then ADR with Mike Powers was ordered. Review hearing set for June 16th. I think that was later continued to today's date. So, Ms. Levitt, from your perspective, what is the current status of these matters?
Judge, I want to advise the court of where we stand on the ADR because that has been a bear of a problem for us. So we reached out to Mike Powers for alternative dispute resolution, specifically mediation style ADR, and his availability when we reached out to him at that time, his earliest was a singular date of August 21st. Ms. Smith and I discussed that and decided that it was in the party's best interest. And in hindsight, we made a mistake. We will both own that. That is in the party's best interest to try to find somebody who could do end of July or early August mediation. We sent emails to, or I sent emails to all the mediators that I have used before. I have about 7 in rotation on a regular basis. And then there are several more that I'm familiar with their mediation, but they were fairly outside of the ballpark of these clients' income ranges. And we have found somebody. Ms. Ortega can do mediation.
Buckle up, guys. Today we're watching a routine status hearing become a turning point. The judge sets the tone, reminding everyone of prior orders while counsel admits mediation has been a bear to schedule. Right away, we see the tug of war, procedure versus practicality, and one attorney owning a scheduling mistake. That small admission sets up why this case keeps circling back to court.
With these parties at an affordable rate. She can do child custody, residency, parenting time mediation for between $1,000 to $1,500 per party. And she can do it, but her first availability is September 2nd, or the second week of September, excuse me. We are emailing with her about the exact date. There was only one mediator who was available earlier than Mr. Powers, but that was Joy Marlin. And I don't know if the court recalls this from prior hearings. Joy Marlin was the initial mediator in this case. And actually the paperwork for the parties from like their last order, not necessarily from this last round of hearings, but from their last order that actually memorialized their last go around, said that the party should return to mediation. And it specifically did reference Ms. Marlin as the possibility, as the mediator for it in lieu of going back to court. However, Mr. Daughtry has objected to Ms. Marlin because of some issues within the paperwork that there's language that calls the party's parenting time shared residency, but then the schedule is not what the court would consider shared residency. It's not 223. It's not week on, week off. Mr. Daughtry has every other weekend. And he believes that that was an error. And I have always operated from the presumption that if the parties have used a prior mediator or ADR coordinator, and there was an issue with them that one of the parties raises, that it's better for the case and it's better for the objectivity of everybody to find a new mediator. So that was the path we took. We have found Ms. Ortega. It has significantly pushed the timeline back as the unfortunate reality of it. So in trying to get sooner than Mr. Powers, we put ourselves in a position to getting later than Mr. Powers, because when we went back to him, of course, August 21st had been taken from us by another family who...
All right, guys, negotiation happens in the margins. Here, counsel walks the court through a minefield of mediator dates, fees, and conflicts of interest. The choice of Ms. Ortega to save clients money exposes the real stakes. Access to ADR depends on who can afford what. That explanation about a $1,000 to $1,500 fee versus $2,500 retainers reveals how economics warp fairness in family disputes.
So we're trying to be realistic to their circumstances and what they can actually afford. And this is where we have come to as we sit here today. The makeup time did occur. The parties have figured out some vacation time between each other, which was a positive co-parenting change. They figured it out between themselves ultimately. So we are seeing some positive things occur in this case, but the mediation is the big piece, and it still needs to occur.
All right, Ms. Smith, what would you add to this?
Your Honor, I agree that we've agreed to use Ms. Ortega, and my client understands that he's basically pushing it off, that we could use Ms. Marlin and have it done sooner, but he would prefer to have somebody who didn't draft this parenting plan. He understands that that means that he's waiting until September in order to have that. Since he's the one asking to modify, we would just ask court approve that timeline since my client is making that choice. However, did want to inform the court that the PFA against my client was tried and dismissed. And so that is no longer at play. And so today, what I would just like the court to address is that the agreed parenting plan on file says that my client has parenting time on alternating weekends from Friday at 8 a.m. to Monday at 8 a.m.
Buckle up, guys, history matters. This segment peels back prior mediation, paperwork errors, and why one party objects to having the original mediator reappointed. We see how a technical phrasing, shared residency, versus actual schedule, becomes ammunition. That dispute over wording shows how legal language can lock families into months of fights rather than solutions.
Today that is existing that gives my client every other weekend. He would pick him up from school. Obviously, he can't have him at 8 a.m. unless school is out. But he would ask that the court order that the parenting plan that is on file be followed in its entirety at this point while we wait on mediation.
Well, the kids aren't in school right now.
That's correct. But he's still having to get
for exchange, right?
But he's not getting him until 4:30 on Fridays at the police station, even though the parenting plan says that he should have him at 8 a.m. on Fridays. And then he's having to bring him back Sundays at 7 instead of Monday morning. So he's losing an overnight that is in the agreed parenting plan. And so we're just asking the court order that the parenting plan be followed in its entirety until we have mediation.
Which begs the question, why isn't it being followed now, Ms. Levitt?
By agreement of the parties, Your Honor. When the child started pre-K over a year ago, they shifted the weekend schedule to be a pickup at 4:30 on Friday for dad and return the child at 7 p.m. on Sunday. And in large part, that was because of dad's work schedule. He had to work Fridays. The child was in pre-K anyway, so an 8 a.m. pickup when the child starts school isn't realistic anyway. And then the Monday morning work schedule, the child has to be in pre-K in Augusta. This year it'll be kindergarten, of course, pre-K in Augusta, and dad couldn't get the child to school in the mornings. This was reached by agreement and followed as the de facto for a year. I will also tell the court, headed into this next school year, dad lives out. He gave the address to the court at our...
All right, guys, here's the human cost. The father claims his court-ordered weekends were whittled away because he lacked counsel and felt forced to agree. The mother's lawyer counters with logistics, preschool, long commutes, and real scheduling concerns. That clash, coercion versus practicality, is the clearest moment where the court must weigh fairness against what's workable for the child.
So would point out that we're going to mediation for a request initially filed by my client to change the schedule, but then a follow-up motion by Mr. Daughtry for shared residency. So now Mr. Daughtry is asking that this court revert back to a parenting plan that now hasn't been followed for a year, make that change right now, and then in September, make the change that comes out of mediation. That's a lot of change in a 60-day window to accommodate Mr. Daughtry essentially changing his mind as to what he wants to do on weekends. I would also point out that he has spent, since our last hearing till now, repeatedly complaining to my client about all the child's activities being in Augusta and about how far it is for him to get there for the activities.
What kind of activities are we talking about?
Like T-ball and summer things like that. The child wanted to do a soccer camp in Augusta, and it aligns the days for the soccer camp. The majority of them align with dad's vacation time, and my client said, hey, he wants to do the soccer camp. I don't really know exactly what your plans are for vacation. If there's a way for him to do it and you take him, I'd still like to sign him up. And he said, well, that's really far for us to take him every day to soccer camp. So it's too far in the summer when everybody has a flexible schedule and can do it. But starting at 6:30, 6:45 in the morning during the school.
Buckle up, guys. The judge draws a pragmatic line. The court rejects long daily commutes and orders a school year schedule that balances parental rights and the child's routine, shorter weekday exchanges, but preserving expanded summer weekends. This ruling is a pivot. It acknowledges both parents' arguments, but prioritizes the child's stability over strict adherence to an outdated plan.
All right, Ms. Smith, anything you want to say in reply?
Your Honor, my client objects that the changes were agreed upon. His position has been throughout this entire time that the changes have been forced upon him, where he did not have counsel, and so he felt like he was not going to get to see his son if he didn't do exactly what mom wanted. And I think the court has seen evidence of that when she withheld parenting time the one time he didn't do what mom wanted. And so he feels like he has been forced into this because he didn't have an attorney, that if he didn't agree to exactly what mom said, he wouldn't get time with his son at all. So he did what she said. The minor child is young. He gets up at 6:30, 6:45 at my client's house on a regular basis. So driving to school in the morning is not going to be a problem for that. And there's a difference between taking him to school one morning a week and being asked to come to activities several days a week in Augusta that are minor child. I mean, he could play t-ball with my client. And so there's a difference in asking him to come daily to Augusta for activities than him asking to be able to have the court-ordered parenting time. He would have to drive to Augusta one morning a week when the child is already awake at that time. This isn't asking the child to wake up any earlier. The child would be awake anyway. He's just asking to follow the court order that he's been prevented from following because he was fearful that he would just be taking his parenting time unilaterally, and he didn't have an attorney to defend that, and he didn't have the money to hire an attorney to defend that. And so this is the court order. The parties never signed anything else saying that this isn't the court order, and he would like to exercise the full parenting time that he was awarded in this mediated court order.
This court disfavors.
All right, guys, details make or break orders. Counsel secures permission for school pickups instead of police station swaps and confirms who will draft the order. There's also a small but important correction about mediator availability, not September 2nd, but the second week. These administrative moments prevent future disputes. They're the quiet diplomacy that keeps litigation from restarting.
The prior schedule should apply. In other words, the expanded schedule from Friday morning to Monday morning, because it's not going to impact any school attendance. So essentially, both parties are right in their own way. The existing parenting plan should be followed until it interferes with the commute to school. And I don't know exactly when his school starts in the fall. It seems to start earlier and earlier each year, but I presume that there's some part of July or August which the father will exercise one of these expanded weekends. And so the existing parenting plan order would apply to these summertime weekends. Do you need any clarification on that, Ms. Smith?
Your Honor, can my client pick up the minor child from school on Friday afternoons instead of meeting at the police station? That wouldn't be a
Why are
commute
they
to
meeting
school.
at the police station?
That was, again, per mom's request. And if he's going to have 4:30 at Friday, there's no reason he can't just pick him up from school on Friday afternoons.
Judge, we don't have any problem with him picking up the child from school on Friday afternoons, but it wouldn't be at 4:30. He'd have to be able to be there when school let out, which is 3:15.
Is that a possibility for him? Can he actually be there physically to pick up the child at 3:15?
Yes.
Well, again, that makes sense. And it appears to be certainly consistent with the best interest of this child. So yes, he can pick up from school.
Buckle up, guys. We finish with a plan. One mediation session, likely half, or full day, then a Zoom review on October 6th at 11 a.m. Counsel promised cooperation. The court encourages compromise for the child's best interest. The practical schedule, mediator choice, and follow-up date turn confusion into a manageable roadmap, and that's the relief everyone hoped for. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.